Breaking: Trump's emergency appeal has been rejected by the Supreme Court. 1 minute ago, in a stunning move, the highest court in the United States refused to intervene. The legal clock just started ticking louder. The decision dropped without warning. A brief order. No sweeping explanation. No dramatic press conference. Just a rejection that now sends shockwaves straight through the political and legal landscape surrounding Donald Trump. This was not a routine filing. This was an emergency appeal, a last-ditch attempt to pause or block lower court proceedings tied to an ongoing legal battle. Trump's legal team had argued that immediate intervention from the Supreme Court was necessary, urgent, critical. They warned of irreversible consequences if the lower court process continued. Tonight, the Supreme Court declined. To understand the magnitude of this moment, you have to look at what was at stake. Trump's attorneys had asked the justices to step in rapidly, seeking relief that could have delayed key actions in the underlying case. Emergency appeals are extraordinary tools. They are not granted lightly. When the Supreme Court agrees to intervene at that level, it signals urgency of the highest order. But in this case, the court said no. That refusal doesn't mean the broader legal fight is over. Far from it. But it does mean that whatever protections or pauses Trump's team was seeking will not come, at least not now, from the nation's highest bench. Why does this matter right now? Because timing is everything. Court schedules are moving, political momentum is shifting, public opinion is volatile. An emergency appeal is often about buying time, stabilizing a situation before it accelerates. With that option denied, the legal machinery below continues forward without interruption. The key players in this unfolding drama are now locked in position. Trump's legal team, determined to fight on multiple fronts. Federal or state prosecutors, depending on the underlying case, pressing their arguments. And the justices of the Supreme Court, who have chosen, at least for now, not to step into the arena. Legal analysts immediately began dissecting the order. Was it procedural, strategic, a signal? The court often issues emergency decisions without detailed explanation, leaving observers to read between the lines. And tonight, the silence from the bench is almost as loud as the ruling itself. Then came the escalation. Within minutes of the decision becoming public, reactions started pouring in. Supporters of Trump called the refusal disappointing and argued that the lower courts are moving too aggressively. Critics described the rejection as a validation of judicial process, proof that extraordinary relief was not justified. But here's where the tension deepens. The denial of an emergency appeal doesn't eliminate the possibility of future Supreme Court involvement. It simply means the justices are not stepping in at this specific juncture. The underlying case continues, deadlines remain, hearings proceed, and that's where the pressure intensifies. Because without a pause, every procedural step in the lower court now carries amplified consequences. Discovery moves forward, motions are argued, evidence disputes are resolved. The case advances. Behind the scenes, strategy rooms are likely in overdrive. Trump's legal advisors must now recalibrate. Do they pursue alternative appellate pathways? Do they narrow arguments? Do they accelerate preparation for trial-level confrontations? The denial also sends a broader message about how the Supreme Court views emergency requests. Historically, the court is cautious. It intervenes only when there is a clear and immediate legal harm that cannot be remedied later. By rejecting this appeal, the court may be signaling that it believes the normal appellate process is sufficient. But politically, the optics are powerful. The headline alone is explosive. Supreme Court rejects Trump emergency appeal. For supporters, it may fuel narratives of institutional resistance. For opponents, it may reinforce arguments that the legal system is functioning independently. And then came the major turning point. Late commentary from constitutional scholars suggested that the court's refusal could accelerate the timeline of the underlying case. Without high court intervention, there is less procedural uncertainty. That clarity, paradoxically, increases the urgency for both sides. If proceedings move faster, decisions could land sooner than anticipated. And in a politically charged environment, speed changes everything. Campaign messaging could shift overnight, fundraising appeals could spike, public rallies may reference the court's decision as either a setback or a rallying cry. International observers are watching closely as well. The stability of American legal institutions is often cited globally as a benchmark. When a former president seeks emergency relief and is denied, it becomes a headline beyond U.S. borders. Economically, markets tend to react to uncertainty. While no immediate dramatic swings were reported, analysts note that prolonged legal battles involving high-profile political figures can inject volatility into policy expectations. Regulatory futures, legislative priorities, even diplomatic tone. Back inside the legal arena, the rejection sharpens focus on the next scheduled court dates. Judges in the lower courts are not bound by political commentary. They proceed based on filings, arguments, and established law. And now, without Supreme Court interruption, they proceed uninterrupted. Trump himself has consistently framed his legal challenges as politically motivated. His public statements emphasize resilience and determination. The rejection of the emergency appeal may become another chapter in that narrative, presented as a hurdle rather than a defeat. Opponents, meanwhile, argue that the judicial process must unfold without special exceptions. They contend that emergency appeals should remain rare and that standard procedures exist for a reason. The clash of narratives is intensifying. Supporters rally around themes of fairness and due process. Critics rally around themes of accountability and institutional integrity. And the Supreme Court, often reluctant to be drawn into political storms, has chosen restraint. Yet the story is far from over. Because emergency appeals are only one tool in a much larger legal arsenal. Appeals can still reach the Supreme Court through traditional channels. Substantive rulings in lower courts can be challenged later. Constitutional questions can resurface. The refusal today closes one door. It does not close the entire building, and that's where suspense deepens. What happens next in the lower court? Will there be new motions filed in response to the accelerated timeline? Could fresh evidence, arguments, or procedural disputes reshape the path forward? Will the Supreme Court revisit the matter later if the stakes evolve? Every development now feels magnified. The legal system moves deliberately, but the political environment moves at lightning speed. And when those two forces collide, the result is tension, unlike anything else in American public life. Tonight's rejection is a moment, a pivotal one, but it is not the final word. The Supreme Court has stepped back, for now. The lower courts advance, the political arena reacts, the public watches, and somewhere behind closed doors, strategies are being rewritten, because in high-stakes legal battles, one decision rarely ends the story. It usually begins the next chapter. Stay alert, the next filing, the next hearing, the next judicial order. It could arrive without warning, and when it does, the impact may be even greater than tonight's shock.